we shall also be asking the deponent to check the door for us to cross-examine him in the apartments.
The Langata police station or any other police station within the Republic of Kenya. And Your Honor, the reason being, and this is a justification, that it will enable the applicant herein, the Republic, through the Independent Policing Oversight Authority, to continue and conclude investigations in respect of the facts, the basis of the arrest of the respondent. Your Honor, our application is based on both law and facts. And to be more specific, Articles 24, 29, 49, of the Constitution and Section 36, capital A, of the Criminal Procedure Code. We will also make references to the decision of the High Court of Kenya at Nakuru, Honorable Justice Joel Ngugi holds so highly, in the decision of Sudi Oscar Kipchumba versus Republic, and this is Criminal Revision number 208 of 2020. You know, fundamentally, that decision of the learned Justice Ngugi, as he then was, because he now sits at the Court of Appeal, cites and makes reference to the decision of the High Court of Kenya at Milimani, delivered 4 years before it by the learned Justice Luka Kimaru, as he then was as well, because he equally sits at the Court of Appeal, in Michael Rotich versus Republic. And we preempt that the defense are likely to run away with Michael Rotich, so we are going to hit hard on it before they get the chance. You know, in summary, what we are requesting this court to do is to issue an order for what the Constitution calls detention continuing. The respondent remains in custody. That's the name that we call it custodial orders, for purposes of completion of investigations. You're not cognizant of the jurisdiction of this court under Section 8, Section 2 of 15. Article 29 is only in passing and for purposes of laying basis that every person, I am paraphrasing, every person has the right to freedom and security of their person, including the respondent. Limitation of rights under the Constitution, save for the rights under Article 25 thereof. Justification. And where, Your Honor, it is established that the kind of limitation we are seeking in nature of detention continuing is the least restrictive measure. So that, Your Honor, once we have established, as we have, that Article 24 permits the limitation of the right to freedom and liberty, then we shall, through my learned senior, take the court through our affidavit to establish the justification. But Your Honor, Article 49(1)(f)(1) sorry, that is 49(1)(g), Your Honor, I'm sorry. And if you allow me to read, an arrested person has the right at the first court appearance to be charged or, and this is important to us, informed of the reason for the detention continuing or to be released. And so out of the three available options under Article 49(1)(g), we have come to court to seek detention continuing. Your Honor, with that legal basis, allow me to make a reference to the learned Joel Ngugi J, as he then was, in Sudi Oscar Kipchumba.
It's his strategy.
Your Honor, I was inviting the court to paragraph 24. My other colleagues prefer to call custodial orders. And it says, at paragraph 24, if you permit me to read, so even while accepting that the text of Article 49(1)(f) may, in certain circumstances and contexts, and we submit like this one, comprehend a situation where a person is presented before a court without being formally charged and is thereby informed of the reasons for his continued detention through the state's application, like ours, to have him so held, the state must satisfy a double test. A, first, the state must persuade the court that it is acting in absolute good faith and that the continued detention of the individual without a charge being preferred, whether provisional or otherwise, is inevitable due to existing exceptional circumstances. So that, Your Honor, through the factual matrix, we are going to establish exceptional circumstances. And B, this is the second part of the test. Second, the state must demonstrate that the continued detention of the individual without charge is the least restrictive action it can take in balancing the quadruple interests. Now, this is very interesting. Quadruple interests present in a potential criminal trial. There is a potential criminal trial, and this is the quadruple interest. Number one, the rights of the accused individual, in this case the respondent, who is likely to be charged in a potential criminal trial. Number two, the public interest, order, and security. You know, it is not in doubt that this is one of the great matters of the greatest public interest in the country at the moment. Number three, the needs to preserve the integrity of the administration of justice. We will discuss that in a minute. And finally, and the interests of victims of crime where appropriate. Yona I dare say kizungu. Yona I dare say kizungu kubwa. Having highlighted those two tests, Your Honor, the state is acting in utmost absolute good faith to have presented the respondent within a reasonable time before court. Other than in the police cells, through the affidavit before you, the respondent has been informed, one, of the reason of his arrest, and two, in insurance law, it's called uberimai fidei. That good faith is furthered by the fact And finally, from my part, in compliance with the need provided for under Article 24 of the Constitution,
the respondent is the custodian of the station records, being an OCS, officer commanding station, and the surveillance system, the CCTV. And this is at the material time under the investigations.
You know, still I'm asking, what will be the deponent in telling this?
Your Honor,
The information the DPP is giving, it is not them who depend. It is the one who depend who should be giving us those paragraphs in paragraph 4. Then the DPP can buttress their submissions based on that. Right now, they...
So you're referring to the CCTV, maybe to refresh,
yes,
to recap.
on the CCTV,
Yes, yes.
We said paragraph 10,
Yes.
the respondent is the custodian of the station records and the surveillance station. Yes, investigations reveal that under paragraph 11 at Central Police Station on that night. Your Honor, given that the respondent is the OCS, we are saying that there's a likelihood that he may interfere with the investigations. Your Honor, we'll be seeking the 21 days. To continue holding the respondent. And in addition to the 21 days, Your Honor, we'll be seeking an order that we access the forms of potential witnesses, the police officers who are on duty, and any other person who was at the vicinity at Central Police Station. And this, Your Honor, we are relying upon paragraph 17 and 18, where we have shown in the paragraphs, we have demonstrated that there's already interference, which has already been done. With that, Your Honor, we will be inviting the deponent, the doc, for the cross-examination.
You can testify.
Yeah, wherever you're comfortable.
Almighty God, the evidence I shall give before this court, touching the matter in question, shall be the truth, the whole truth, and nothing but the truth. So help me God.
Yes, did you state to the court your full name?
Your Honor, I am Abdurrahman Jibril. Jibril for you, J-I-B-R-I-L. I'm a Senior Assistant Director, Investigations with the Independent Police and Oversight Authority.
Yes, we did report
upon this affidavit that is before court.
Yes, Your Honor.
Yes, kindly proceed with the affidavit. There will be questions needed from the defense.
Thank you, Your Honor. Your Honor, I am one of the investigating officers in the ongoing investigations that IPOA is currently conducting in regards to the brutal murder of Albert Omondi Ojwang. This is pursuant to Section 6, 7, and 25 of the IPOA Act. Your Honor, on 8th day of June 2025, IPOA learned the death of Albert Ojwang while in police custody at Central Police Station within Nairobi County. Your Honor, the authority immediately initiated investigations to unravel the circumstances surrounding the gruesome death of the deceased. Your Honor, so far, our preliminary investigations have revealed that the deceased was arrested following a complaint by the Deputy Inspector General of Police.
Your Honor,
Yes, Counsel.
all that the witness is saying has been said. You can only adopt the neutral example. Because unless there's any other crucial information.
That's another one. That's okay.
Yeah, I was of the view, but just give a highlight, not necessarily going paragraph by paragraph, just a highlight, and then we can adopt it. Just a brief highlight, yeah? Of, you okay with whatever you've said so far?
Yes.
And whatever you've averred in the affidavit, yeah? So we can proceed with the cross-examination then?
Yes.
Is that okay? The other team from the state?
That's actually not that.
Okay.
They can proceed to examine on the affidavit.
Thank you. Your Honor, I'll be asking the witness to take the brief.
So, Mr. Dunstan, maybe just for housekeeping and good order, how many of you will cross-examine him?
3.
3. You, yourself, and who else?
Me, what? Bangali.
So only 3 of you from
Yes,
the battery
we'll
of
cross-examine.
the 3 of you
Others will submit.
I think that is okay.
Mr. Jibril,
Yes, Your Honor.
can you confirm your position at IPOA over this matter?
You're asking my rank?
Obvious. That's what I'm asking.
Your Honor, as indicated, I'm a senior assistant director in investigations.
And confirm that you are an investigator.
Yes, Your Honor.
Are you an investigator in the purpose and the name or the position of the National Police Act?
IPOA Act.
Under IPOA Act. And under IPOA Act, is it true that you have still arrested powers?
Yes.
Under which section?
Your Honor, Section 7 of the IPOA Act and Section 7 of the IPOA Regulation Act actually gives me the powers, privileges, and immunities of a police officer.
So section 7. And which section?
Both Section 7 in the IPOA Act and Section 7 of the IPOA Regulations Act.
Gives you the powers as that of a police officer.
Yes, sir.
And in this matter, you are now actively participating pursuant to those provisions as an investigator.
Yes, Your Honor.
Are you well conversant with the law?
Depends on which area you want to ask.
Are you, you know, some of us went to teach and we became lawyers. Some people are mad about that. Do you have any legal training?
Yes, yes, I do.
Could you refer the court to your legal training?
I'm an advocate of the High Court of Kenya.
Thank you. You are an advocate of the High Court of Kenya. Look at the Criminal Procedure Code, Section 386 as an act.
And again, goes into the earlier intended preliminary objection, which we have had sight of, where the argument, in a sense, is that this matter, now we have had a copy, although it's not filed.
Okay.
This matter should have been the subject of an inquest and not a miscellaneous application.
Okay.
So that because we are alert, the defense should not try through the window to bring in a preliminary objection which they admitted not to have filed.
Okay.
But more importantly, that this is a witness of facts, not a witness of the law. We can deal with the law between the lawyers. Thank you.
But Your Honor,
Yes, Mr. Ombeta.
is the law a fact? Yes, it is. Is he in a court of law? Yes, he is.
Facts of the.
After I've asked the question,
Yes.
then that is when an inference can be done, whether it's a question of law or a question of fact.
All right.
I've not asked what.
There is no reference to Section 386 in the affidavit. They cannot go to it because it is not a matter of fact. If you pointed to us the paragraph looking at Section 386, which we referred to, there will be no objection from our end. But because affidavits are pleadings of fact, we plead with you to reject the invitation of the witness to look at Section 386 or any other provision of the law. Thank you.
I think he was referring to Section 386.
Yeah, I just only
So, let's not convolute it, yeah? Let's limit, it's an affidavit.
purely,
Yeah,
I've
it's
not
an
asked any question, Your Honor. If we only had what I've asked you,
Okay.
and I ask a question of law, then the court can stop.
Okay, then proceed and ask.
Let him have that. Let him look at.
But you know, once you point it to the law, then it means it's it's a point of law.
And that exactly is our objection, that we can't refer to the law. That maybe a counsel is not understanding our objection.
Very well.
Maybe counsel, maybe rather than asking him to look at the law, yeah, why don't you put the questions to him?
Correct.
Just put the question, rather than, you know, us going to the...
From your affidavit, confirm the place of death of the late.
Central Police Station cells, Your Honor.
Central Police Station cells. From the IPOA Act, provide the mandate for you to investigate somebody dead in a police cell.
Yes, Your Honor.
Read, show the court. Because you have confirmed the scene of death is at the police cell. Which mandate gives you that power? Let him answer.
Your Honor, we are still objecting.
Yes.
Counsel is still taking the same.
He came under the act. You know, section in this miscellaneous application, paragraph 3, they must have said under which mandate they are coming before this court.
Don't give him answers. Don't give him answers.
And these are witness.
These are witness now.
He's not an advocate. Let him come in front of you. Let him not be given answers.
No, Your Honor. We plead with our colleagues to just remain respectful.
Indeed.
We know that they are very good people. Let us maintain the decorum. What we are asking is, as the court has suggested, put the law to the witness. Don't ask the witness to refer to the law.
Very well.
We do not mind if you read the law to him and ask questions.
Read paragraph 3 of your draft.
Please read for me so that I can answer.
No, you read it. I didn't write it.
Which one?
Paragraph 3.
That investigations by IPOA are pursuant to section 6A, 7.1, and 25.1 of the IPOA Act.
Is that the law?
Yes,
Is that a fact or that is the law?
that is a fact as per this affidavit.
That's what I'm saying.
Yes,
You have quoted the law. True.
yes.
Therefore, it is not wrong to ask you a question of law because it is you as in your affidavit taught. Give me the law that gives you mandate to investigate a person who dies in a police cell. That is it.
I have indicated the sections. 6.1, 7.1.
Tell the court, just tell the court.
Your Honor, I have indicated section 6A, 7.1 and 25, one of the IPOA Act.
Could you kindly read to the court those sections that gives you that number? The IPOA, just read to the court those sections for the benefit of the whole world. We don't work for IPOA.
Your Honor, because we did not anticipate
Yes.
that a witness of fact will be made to read the law, we didn't carry a copy of the IPOA Act. If they insist that they want to read it, let them just give us the...
We
this day and age of technology,
from selective amnesia when he is cornered. It is there on any phone. Just read the phone. Read the section. 6, you read.
Okay. Section 6, Your Honor talks about functions of the authority.
Yes.
Here means IPOA.
Yes.
That the functions of the authority shall be 6A, investigate any complaints related to disciplinary or criminal offenses committed by any member of the service, whether on its own motion or on receipt of a complaint, and make recommendations to the relevant authorities, including recommendations for prosecution, compensation, internal disciplinary action, or any other appropriate relief, and shall make public the response received to these recommendations. Shall I continue?
Yeah, anywhere where the death of a person in police, specifically, that's all. My question is specific.
Your Honor.
Your Honor, this is
Can we allow the witness to read?
this is a question.
Sorry, Your Honor.
Before you even say anything,
Yes.
this is a question that has been put to this witness. It is about what he has said in his affidavit.
Yes.
He's being asked to justify why he is here and what gives him the powers. The state, who has not been asked a question, can now stand and start giving him answers or start supporting him. Let him answer.
Yeah, if Mr. Witty,
Yes.
you have
Yes, Your Honor, I just wanted to indicate.
yes.
Section 6 has been referred to in the affidavit. The witness has been asked to read, he has read the affidavit.
Yes.
The witness is being asked about the law supporting an action which is not in the affidavit. That's where the difference is. The
But I
witness is
think-
saying that section 6 allows us to do A, B, C. But counsel is asking, does the law allow you to do A, X, which is not in the affidavit? We believe that by him having cited to us the paragraphs to ask questions on, asking the witness about the law allowing you to investigate deaths in cell, which we have not referred to in the affidavit, is going outside the affidavit.
But I
we
think,
would be guided.
Mr. Witty, I think it's the bane of contention. So let him answer. If it falls under the ambit of that section 6, let him just say
That's right,
it
that's right.
falls
That's
under that provision of the law, and let's leave it at that.
That's right.
Yes.
That's right.
Yes.
And the question we are here about is specific to death inside a police cell. And that is all I'm saying. If he says that section,
Yes.
then the court will go and make a ruling out. That's all we're asking. In relation to death in a police cell.
In police custody.
It's not you to set my question. I've asked you my question. You can't set a question and answer yourself.
So, Mr. Jibril,
Yes.
If it's not
I
there,
think
it's not there.
the question is, do you have the powers to investigate?
We have powers to investigate death that
Death.
occurs under police custody.
And that's good enough.
Yes.
Let's go
And
to the next
custody
one.
is-
Doesn't mean the
Yes.
court has gotten what we have asked.
Yes,
The question has been answered. We'll do submissions on it. That's all.
Yes.
Let's go to paragraph. Paragraph 7. You have paragraph 7?
Yes.
Read to the court what that paragraph says.
Your Honor, the paragraph says that the respondent was arrested on 13th June 2025 by DCI officers and subsequently handed over to IPOA and was later booked at the Dhaka police station by OB 50-13-6 of 25 at 18:05 hours.
The DCI officers arrested him at what time, according to your.
said around 3.
You read exactly what you said.
I've not indicated the time.
That's what I'm asking.
Yes,
It is not indicated when the DCI officers are arrested.
yes,
Where did they arrest him?
at the DCI headquarters.
And not Eldoret
No, Your Honor.
confirmed that the accused was not arrested at Eldoret, the
According,
respondent.
according to the officers who handed over me to Mr. TAALAM, the officers informed me that they arrested him at the DCI headquarters.
Thank you. I'm putting to you that IPOA released false information to the public that he was arrested in Eldoret en route to escape to Uganda.
That is not in my affidavit.
I'm saying what is in social media is that the respondent.
Your Honor,
was
I can
arrested-
only answer what is in this affidavit.
Sorry, Your Honor.
Let's not digress to those issues of
Yes.
social media.
Let's proceed
Let's-
on the question of arrest. Are you aware the Director of Criminal Investigation, my friend Mr. Mohammed Amin, said the respondent is a person of interest?
That is not in my affidavit.
That's why I said, are you aware? If you are not aware, you are not aware.
Counsel, please ask me what is in this affidavit. I'm not going to, Your Honor, I'm not going to answer anything outside
All
the
right.
affidavit.
I put it to you that based on the DCI mentioning a respondent, on that day at 2 p.m., he presented himself to the DCI headquarters in the presence of his advocate, Juan Keto. Were you aware of that?
If you say so.
Thank you. Putting it to you. And the DCI authorized these officers together with the advocate to present the respondent to IPOA headquarters.
Your Honor, you have said time and again.
I'm putting it to
no,
you.
no, please,
You don't need to
no,
answer.
no, please answer me ask me what is in my affidavit. Let's stop charges, Counsel.
Counsel, I've only put it to you, I've not asked you any question.
Is it in my affidavit?
I'm
The
putting
question
it
I'm
to
asking to you is it in my
For
affidavit?
the
The answer is
benefit
no.
of the court, I'm putting it to you, then I'll ask you where you are saying arrested.
Your Honor, I will decline to answer anything which is not in my
I've not
affidavit.
asked. I've not asked.
Then please ask.
I put it to you that the officers handed over the respondent to IPOA in the presence of Mr. Keto. As I put it to you, for the record purposes.
Samson TAALAM was brought to IPOA head office by DCI officers.
And he did record a statement at IPOA in the presence of his advocate, Juan Kiprona. Who is he?
Is that my affidavit?
I'm putting it to you, counsel. You are a counsel. When it's a question, I'll ask you a question. I'm
Please-
only putting it to you
Please ask
for
me
knowledge
questions.
purposes. So now, if those are the facts, look at the paragraph you said he was arrested. Paragraph 7. Now I'll ask you questions from there. Read.
I have read and read. What is the question, please?
It's a long day.
No, it's a long day, yeah? It's okay. It's okay.
When the state is rich, it can bring water for both of us and council. It's a long day. Can you confirm that paragraph 7 is not true, that he was arrested by the DCI officers?
The respondent was arrested by DCI officers after he presented himself and brought to IPOA.
Do you have any evidence material to that effect? I've given you the scenario the way it was.
The fact that he was brought under the escort of DCI officers means he was arrested and brought to IPOA
The
office.
court has taken that. Let's go further.
Sorry, Your Honor, I think this may be my last objection.
Yes.
We hope that counsel is not proposing to court that he has an alternative set of facts which the court should take note of, because counsel is not a witness. If he wants to give us his alternative facts, we would expect an affidavit so that we also put him on a dock and cross-examine him. Until then, the only factual matrix we have is the one given by the witness before.
The only way to prove falsehoods is by bringing facts that are truth. The affidavit is full of falsehoods. We are putting exactly the scenario, and your witness has not recounted any.
So, sorry. You know, I am a believer on the law and procedure. What I understand by the law of affidavits is that a person cannot give us factual matters, especially a lawyer or an advocate, from the bar. Right now, we have affidavit evidence given by this office, having an alternative set of facts, which may be true. We have no reason to doubt it. But until we have an affidavit, all that is telling us is, I put it to you, and we hope it does not go to evidence.
No, counsel, just to allay your fears.
Yes.
The evidence that I'm documenting is from him.
That's right. Thank you very
Not
much.
from Mr. Danstan.
Thank you.
Because as you put it rightly, you know, he's not giving evidence. If
All
he
right.
have anything, he knows the procedure. He's a teacher of the law. He
Yes,
knows how
that's
to.
why I told you,
Yeah.
now is mature to be a judge of the high court. Thank you very much. Let's proceed, Your Honor. Paragraph 9.
Yes, Your Honor.
Paragraph 9.
Yes.
You have said what? About the position of the OCS?
The respondent at the material time of the incident, he was officer commanding Central Police Station, exercising command of the Central Police Station, hence persons of influence, and has capacity to interfere with the ongoing investigations and likely witness.
Do you have any evidence to show that he was in full command of the police station?
As an OCS,
No,
that
no,
is,
I've asked a simple question. It is either you have it or you don't have it. Do you have anything, either duty roster or something showing he was on duty
Yeah.
and in command?
Your Honor, what the advocate is asking is that you are the presiding magistrate here. Do you have the power of this council?
We have agreed that you don't have. It really went to law school.
Mr. Danstan, if you don't want answers to those questions that you're putting, and
I
you're really
know.
putting a lot of putting in, you know, yeah. So just that.
Your Honor, we have our own legal theory.
Yes.
Allow us to proceed.
Okay.
What is relevant, record. What
Indeed.
is not relevant, leave it. I put it to you that the OCS left the police station and the deputy was in command as an OCS.
That is not in my affidavit.
Well, and I put it to you that the OCS was never near Central Police Station.
That is not in my affidavit.
Thank you. The world has heard this, don't you? Let's go, paragraph 15. On the question of him likely to plan. You there?
Yes,
We have agreed there is no any material presented.
yes, nothing
Thank you.
attached.
Let's proceed. Paragraph 10.
We go back.
Oh, I asked you paragraph
15,
15.
yes.
I'm going to paragraph 16, sorry. Still no material attacked. It's either very serious material you have kept, no material attacked.
Yes, Your Honor.
Thank you. Paragraph 17 about the CCTV.
No material attached, Your Honor.
Thank you very much. Paragraph 18,
No material attached.
no material attack. Paragraph 17, I've gone back because there's a question I want to ask.
Please ask.
You have said about the CCTV cameras. Do you have possession of the scene of crime as of now? is in possession of the scene of crime?
The scene of crime was processed and released. Remember, that's a forestation. You cannot hold a station as a crime scene for a very long time. So we have released to the relevant authorities.
Is that on off? Because I was there yesterday. It's not true that the scene of crime has been released to the police.
And
Is it still a scene of crime, or it is non-operational police station?
that question is not, it's not in the evidence.
You've run very fast. You could not lie that that is it. So you cannot, there's no material to show that.
Nothing attached, Your Honor.
Paragraph 19. You've read it?
Yes, Your Honor.
And 21, they're the same?
What's the question? No material attached.
There is no material attached.
Yes.
That's very, very critical to us. Paragraph 22. I still ask you this question about the blue code for silence.
I will refer you to the High Court decision.
Tell the court. This is a lawyer, he knows the court decision.
Court of Appeal decision.
Give the court that decision.
In the Titus Ngamau case, 2020. It was a phrase coined by who was dealing with that.
And I remind you, Cliff is the one who argued that matter.
Yes.
He'll face you over that matter.
It's okay.
He's the one who argued that matter. Cliff will deal with the blue code. Paragraph. Do you have anything to show that is a danger to anybody of the public?
Nothing attached.
So it is an apprehension.
Yes, Your Honor.
Thank you. It is an apprehension. Lawyers swear to be court officers. It is an apprehension. And you are very aware that the National Police Service is the one mandated in this country, including the already convicted murderers. You're aware of that?
Not available.
No, no, no. You will fail to be not understanding what I'm asking. I'm asking you this question. The duty to protect life and property falls under the police.
If you say so.
And this country is not a banana country where the rule of law. So it is not right to say you are preserving his life in cell. And he pays taxes. Everybody pays taxes to be protected. And that it will be dealt with in the cases that I've talked about. Now, what other reason do you need him in cell to detain him for 21 days?
All I stated
What do you specifically want him to do?
All I've stated in my affidavit.
Is there any other reason we have not dealt with?
Everything I require, I have indicated in my affidavit.
Confirm you have his phones.
His phone.
His phone, you have it.
Yes.
And you are seeking this court. Did you have the court order to possess that phone?
I don't need a court order to possess a phone.
Do you need a court order to get access to the phone?
Yes, I do.
Where is the provision that does not allow you to have authority to possess?
It's a
Your Honor,
seizure.
surely.
Which is
Sorry, no. Your Honor, where is the provision that does not allow you? Surely.
Where is
You
the
are asking
provision?
for a provision which does not allow you. This is a negative provision, does not exist in our law. He should tell us the positive provision, and counsel can put it. He can continue putting it to him that this provision does not allow you, not the negative provision.
Maybe rephrase your question, Mr.
I'm rephrasing.
Sure,
You know, which as a prophet is preparing for the judgeship.
Okay.
You need him 21 days for the sole purpose of granting access. Is it him who grants access or the court?
No, Your Honor.
Who grants?
I need the 21 days to complete my investigations.
I've asked a question specific. Do you need my client in cells for the purpose of analyzing the phone?
I need your client in custody for 21 days to complete my investigations.
I've asked a simple question. Is there any role he's required to do in forensic analysis of our phone?
I'm not an expert in forensic analysis, so I cannot say.
So, your varmints are not based on any scientific, because you never consulted a forensic expert. It is you swearing 21 days.
Yes.
And I've asked you, show the court why 21 days? Why do you need him specifically?
Your Honor, the issue is not about only phone extraction. It's not only about phone analysis.
What else?
I have said to complete my entire investigations that entail so many things. Among them, what you have stated.
And lastly, you have already attached the order in your application. Look at it. We have an order. True. Makori, this is a competent advocate and witness. Let him answer.
No, I'm just.
I have seen an
I'm
annexure
just-
here.
Can I check, yes?
I've seen an annexure there. We were given an annexure that has. Is it yours
Yes.
or disowned it?
No, it's ours.
Very well. Let me ask you the question. You are certain you are getting
It's a draft.
these orders?
Counsel, this is
No.
it's a draft. It's a draft.
Which is saying, is the office of the DPP or IPOA that gives the orders, or is the landed court? What is the import of you drafting an order? Is it a formality that in this court already you have decided, not the court to decide? Who decides? I hope it ceases
Your
from
Honor,
being
I hope
the norm.
we can save time by admitting that the application was drawn by the office of the DPP.
Indeed.
What we have annexed as an order is a draft order. It is not the first time today, the 6th, is it 18? It has been done since I was a law student at the University of Nairobi, where we do draft orders. The court can reject it, it's not binding on the court. So that we save time for counsel and his client, we
Which
can,
have only for good practice.
we admit that we-
Avoid doing the judicial work. Leave the courts to do their works.
So maybe Mr. Whitty, let's not delve so much on that, yeah? I think what Mr. Whitty is saying is just a practice that they have adopted from the DPP's end, which is not a good practice
It
anyway.
is not good practice.
So let's leave it at that.
If I sat in that office, I wouldn't allow that. But I was chased. Thank you very much. Let me allow Mr. Kangai to proceed.
To confirm to the Honorable Court that indeed one person of interest in the matter surrounding the death of the late Albert Wang is the Deputy DIG Edwin Lagat.
Please, repeat the question.
I want you to confirm to the Honorable Court that the late Albert Wang was arrested pursuant to a complaint made by the DIG, Mr. Edwin Lagat.
Yes, Your Honor.
Thank you. You also want to confirm to the court that from your preliminary investigations, the late Albert Ojwang was arrested and put in police cell, largely due to the complaint that was made by Mr. Eliud Lagat. Is that correct?
Yes, Your Honor.
Thank you. You confirm to the court that the investigations you seek time to continue with are investigations meant to assist you to unravel the persons who should be held culpable for the death of Albert Ojwang. Is that correct?
Yes, Your Honor.
Thank you for me.
No, no, no.
I mean,
Your Honor, we have agreed that I will be cross-examined on what is in this amendment. The chairman of Independent Tourism Oversight Authority's name or his position is not in my affidavit.
But you know, you come from that
Yes.
or background of
Yes.
IPOA, so it's
And the council knows who is the chair of the IPOA.
please answer the question. Who is the head of the body where you hail from?
We don't have a head. IPOA does not have a head.
So who is the chair of the IPOA?
Yes, that should be a right question. The chair of
Answer.
IPOA
Answer, yes.
is one Ahmed Hassan Issa.
Thank you. Thank you. Now, you confirm to Your Honor that there was a joint press conference on the 9th day of June 2025. Is that correct?
Your Honor,
No,
I'm not going to answer anything outside my affidavit.
Your Honor, if you permit me, just to also give context why I'm asking this question. Your Honor, my learned senior and friend, Mr. J.V. Owiti, went to a very large extent in explaining the authority that was made by my Lord Professor Joel Ngugi in the Oscar Sudi case. Some of the parameters that were set by the Honorable Court were two. I think that is paragraph 24 of that authority. On the question about bad faith, the question about exceptional circumstances, and lastly, the balance of the quadruple rights that the court should look at. One of the items that we have a duty and responsibility to prove to you is to demonstrate to you that indeed there is an element of bad faith in the application that has been made before you. And that is why my questions are aimed at eliciting some of these facts based on the evidence that is going to present before you.
okay.
So, Your Honor, I plead with humility that counsel, my colleague, I even suppose he's my senior. My senior should just
No, I'm not
be
your senior.
kind enough to
Not your
respond.
senior.
So,
Yes,
Mr.
it looks like
Jibril,
deceitful,
if
but-
yeah,
Your Honor,
what you can answer, just answer. If you can't answer, you don't have to answer. Yeah. What you can answer, what is in your information, whatever you have in your knowledge, just answer. If you don't have,
Your Honor,
You cannot argue with the court when you have made a decision.
order.
You've made a decision.
Chair,
You cannot argue with the court.
let me say this. Let me say this for the record. No, let me say it for the record. And Your Honor, protect me.
yes,
The counsel who's on the floor asking questions should only answer.
okay.
Learned senior should stop pointing at me.
Who is this?
You will have your time to ask the questions if you require.
Your Honor, explain.
The second, Your Honor, the second point I'm making here is that anything outside this affidavit, whether our chair...
It's not within your knowledge.
It's not within my knowledge. And please stop asking me. Anything outside this, I'm not ready to answer. It's not within my knowledge. And
Your Honor,
believe.
what is the basis of what happens to your ruling?
And after all, Your Honor,
I
the
think-
application we are making is about an extension of continued detention of the suspect.
This is bad.
It's not about what happened on the backyard.
And you know
What
that's
you're
why,
pointing is bad faith.
Mr. Jibril, that's why he was trying to lay a basis, Mr. Shadrach Wamboi.
We are done for 2 minutes. Get advice by Makori and the others.
You're just give us a minute.
Yeah.
So we take a break.
Yeah, we'll take a break.
We don't need a break. I think just
No,
one-
we don't need a break. We don't need a break.
just 1 minute.
Okay, it's okay. So the court is still in session. Kindly, the court is still in session. If you have to converse, just do so quietly. Indeed. So I'll allow Mr. Shadrach Wamboi to proceed.
Thank you.
Yes.
Mr. Jibril,
Yes.
counsel, please confirm to Your Honor that there was a joint press of Mr. DIG Eliud Lagat and the Inspector General of Police and others
I'm not aware.
You are not aware. Thank you. So you have not, you're not held a joint press conference with one of the persons who's been constantly mentioned in the death of the late Albert Ojwang. You have no information, isn't it?
Your Honor, the chair attends several.
Yes, paragraph 27. You have made mention that the reason why you are inviting the court to order the pre-charge detention of the suspect before court is because you have fear that he might run away from the jurisdiction of this court, isn't it?
Yes.
Have you, in your well-elaborated affidavit, demonstrated an instance?
Now, we see VR that records the events of that fateful day in the forensics team.
Yes.
Thank you. That's all.
Yes, Sophie.
Your Honor, we would love a few minutes of re-exam.
Okay.
That follows cross-examination. Attached to your investigations up to now on a scale of 0 to 100%. Doesn't have to be accurate approximation.
49%.
49%. So I can mathematically say this as direct evidence that you're saying there is 51% of investigations to be done.
Yes, Your Honor.
So that there are questions about who is in charge of the cells, who is in charge of who is in command of the station. Do those questions relate to the remainder of your investigations?
Yes, they do.
Now, to ask another direct question, are the questions from the defense some of the things you need to investigate to complete your investigations?
Yes, Your Honor.
Thank you very much, Your Honor. I'll hand over to Mr. Jackson.
Just one question in the examination. You have been asked whether you have attached any document relating to, I think it was paragraph 6A, some paragraphs in the affidavit, whether you have attached anything to show that even the respondent is a flight risk. Why do you need the respondent in custody? Is there any reason why you have not attached?
Yes, Your Honor. The reason I have not attached what I've collected so far, the 49% I'm talking about, is that it will jeopardize the investigations. And this is actually to protect the integrity of the investigations. That's why we cannot divulge much.
Thank you very much. I believe that is all from my end.
Investigation must also adduce the reasons necessitating the continued holding of the suspect in custody. So the question that begs our attention at this juncture, Your Honor, is whether there are reasons necessitating the continued detention of the respondent. And we submit, Your Honor, in negative, that the investigations have not adduced any cogent reasons necessitating continued detention of the respondent. And Your Honor, my learned friend, they have already gone through the cross-examination limb by limb in the entire affidavit. But if you may permit me only to refer you to 2 or 3 salient issues, Your Honor, in order to illuminate why this motion application is bereft of meat and substance to stand on. First, Your Honor, I would refer you, Your Honor, to look at paragraphs 9, 10, 11, and 20 of the affidavit. They are building a case that you should continue detaining the respondent because it's likely to interfere with the investigation. We submit, Your Honor, that that is not a cogent reason. And we'll invite you, Your Honor, to consider the authority which we have provided, that is Republic versus Mercy Chebet. It is a 2022 decision whereby Justice Gigonyo has indicated succinctly, and I'll humbly refer you, Your Honor, to paragraphs 17, 18, and 19 of that decision, whereby the High Court has settled the law that for such a threshold to succeed, the investigation must tender material information to the Honorable Court to demonstrate the nexus link that is between the respondent and the likelihood of interference. And I will also refer you, Your Honor, to also adopt the reasoning of Justice Mutuku in Republic versus William Chichiri and Godfrey Kirui, whereby the same threshold.
Your Honor, this is not an objection.
Yes.
It's an humble plea that counsel shares the decision with us, and that it is generous enough that he also points out the paragraph that is paraphrasing,
Indeed.
so that we are able to respond.
Your Honor, we have already filed our list and digest of authorities dated in 16th of June 2025, and you can confirm, Your Honor, that they are there. The decisions are there.
Re-exam has told this court that they are in control of certain important exhibits which are not within reach of our clients. There is no way to interfere with those items, exhibits, which are in control of IPOA. Your Honor, the second aspect, which I believe will be addressed by my learned seniors, is the aspect which came out in the affidavit, the issue of forensic analysis. The forensic analysis of the phone, the gadgets, will be done and shall be done in the absence of our clients. IPOA has officers capable of doing that job conclusively without any input from our clients. The attempt by the applicants to say that our client should be in custody while this process is going on should not be entertained by this court. This court, Your Honor, should abide by the binding decision in Professor Ngugi's decision and release our clients on reasonable bail, which my colleagues have suggested, and put even other conditions which our client is willing and ready to abide by. Those conditions, the discretion is with the court. We therefore submit that the application has fallen short of meeting the threshold set by various decisions cited by my colleague and have been supplied to the court, meeting the requirements of compelling reasons. Finally, Your Honor, the affidavit that was filed before this court does not produce, does not even have did not even attempt to convince you for those compelling reasons. With that, Your Honor, I get rest.
An obligation to give you compelling reasons. It's an obligation. It is nothing less than that. Your Honor, if then they have failed in that particular point, what then becomes of that article? Does it become absolute? Once they fail, and I'm saying they have failed at least miserably. Why am I saying this, Your Honor? Because if you look at Article 49, and this one was also in the Republic versus Oyamo case, the court has indicated what is supposed to be a compelling reason. That's in paragraph number 23.
Sure.
What does the court say something to do with company? And this is the Court of Appeal decision in the realm of public. It must be something that is forceful, something that is so convincing, something that is so strong that the court cannot ignore it. Cannot ignore it. Now, Your Honor, once we have seen that, then the state has come and told you they want the suspect, or the respondent, to be in custody because they want to investigate, or they want to have access to his phones. What they did not tell you is that he gave them the passwords, and they're keeping quiet about it. And if they want the password, we can give it here in court now, so that at that point, ya kutaka simu is out of the window. Let's finish that one. It's a simple thing, a 1 minute thing, doesn't need 21 days. They tell you that there are CCTVs that are within Central Police Station. And that the suspect, the respondent might interfere with them. But the investigating officer has told you clearly they have taken the material that was required. He called it a DVI. That is the most important one. So what they have there is a shell. And that's the reason why they can't pick it, and that's why the OCS here cannot pick it. So that is the second point. That issue about the CCTV, we kill it right now. They have nothing on it. Then they're telling you they are going to interfere with the investigation. But in his affidavit, and what he has said here on oath, is that, in fact, I've given him a password. It is yes,
We have given him
they are telling you.
Sir Jibril, it's okay. You don't have to take it, eh?
The issue is not about the SIM or the password.
Yes.
You can't testify. You devise a lot of things.
Okay.
You are part of the special also. I'm running the show.
Yes.
Now they are telling you about witnesses. They are not telling you in the affidavit which witnesses, but they are telling you something else that is imaginary. That they are yet to get some other witnesses who they are going to record their statements. What does that show you, Your Honor? That the OCS does not have the names of those witnesses or does not know them. Does not know them. Such that if we come then to the issue of witnesses and interference with them, it is finished. One of the reasons that the court wants to grant bail on a key person is whether he's going to appear in court or will appear where is required. Why is this important? Let us look at the antecedents of their respondents. When the IO here called him, did he appear? Yes. When he was told to go and record a statement, did he appear? He did, and recorded a statement under inquiry. When the DCI director himself spoke and made some wild allegation in Parliament, the OCS woke up by himself and took himself to the Gigiri police station, headquarters CID, and asked, do you need anything from me? Look at this kind of person we are talking about. Do you need anything from me? Then they arrested him. Why would you deny him bail, Your Honor, when such a person has exhibited a person who is capable to cooperate and even volunteers before they get those Subarus to go and pick him? He volunteers. So today, we are talking of a person who knows the law and respects it. Those are the grounds that they had for you today, Your Honor. So what else remains? Now let us go back to that issue of the definition. Then have they convinced you, Your Honor?
And I'm saying they have not. And that is why I will agree with my learned colleague that if you gave him a cash bill of 7K, that is fine. In fact, for me, I'd say free bond. Because at the time he was going to those officers, he was okay. There was no money, there was no cash bill, but he went. That shows a person willing to come to court. They quote Article 19, they quote all those articles in the law. But you see, Your Honor, today, let us agree. Why do we have these fundamental rights? It is so that we can protect this kind of person from this kind of people. The police. That is why you have these fundamental rights. And Article 19 is quite clear, and it's my favorite, that these fundamental rights, who do they belong to, Your Honor? They belong to an individual and not the state. Not the state. Once they know that those fundamental rights exist, they come to Article 20, which is very clear and says it binds all state organs, including the court, including the prosecution, and including the officers, the police officers. That includes also IPOA.
And on that ground, as a father, he wishes to pass condolences to the family of the deceased. As a father. As a husband, he seeks this court to take judicial notice that he has a home in Eldoret. And is ready, once the court agrees with his application for bail, not to set foot, not only in Central Police Station, but anywhere in Nairobi and the environs. He is still a police officer, though on interdiction. He understands the weight of trying to get contact with the victims. He knows it. You know, this is a man who was given guarantee.
Release him on free bond. You know, this court is bound by Section 60 of the Evidence Act, and this is 60, subsection 1, subsection O, to take judicial notice of matters of public notoriety. Judicial notice of matters of public notoriety. This court is human and does not live in vacuum. This court has eyes. You can see the number of media officers here. You can see the number of Kenyans in court today. This matter cannot be treated with a lack of seriousness. And what is the matter? The matter is that we are saying a Kenyan died in a Kenyan police station. And that Kenyan is identified as Albert Ojwang. You know, of course, we are both Luos, but that's not why I'm making this argument. True. And that is a disclosure of conflict, possible conflict if there was. There is also admission from the defense that the person sitting as the respondent before you is the OCS. While they had questioned it in their affidavit, they have admitted several. And not just the OCS, is the OCS of, according to Mr. OMBETA, one of the greatest stations in Kenya. Allow us 21 days to complete investigations. If the investigations are complete before the 21 days, Mr. Jibril is a good man, except that he gets a little angered like me sometimes. If we complete these investigations before the 21 days, Mr. Jibril, you can confirm we can come back to court.
Yes, Your Honor, I do confirm.
We pray with you that approximate days will do justice, not just to us, but also the respondent, so that we establish, as his advocates are suggesting, that he was not involved in this matter. As I conclude, Your Honor, there is a deliberate distinction by prioritization of Article 49(1)G and Article 49(1)H. I have always believed that when provisions of the law are put distinctly and separately, they mean different things. So that on the burden and standard of proof, Article 49(1)G, which requires at first appearance that he be charged or informed of the reason for his detention or to be released. Once we have given the reason, we have met the threshold. And that the arguments have been made, and that explains why most of the decisions that have been presented to you are decisions on bail pending trial. So that all we needed, in my view, in my very respectful view, is that the threshold is met once the reason is given and it is satisfactory to the court. The arguments about compelling reasons, arguable reasons, are reasons which are better still placed on arguments of bond pending trial. Let me hit the last point, which is apprehension vis-a-vis likelihood. I have heard Mr. OMBETA, who I respect so much because the decision in Dwight Sagarai is one of my best read decisions in this country, tell this court to ignore the bail and bond policy guidelines. Although he said it in passing, but that was very unfortunate in my view. Because the bail and bond policy guidelines is intended to standardize the application of the law on bail and bond in Kenya. And if I get it right, I think it is clause 4.9 of the bail and bond policy guidelines. The word likelihood is used at least 3 times. So that the likelihood to interfere with investigations is a sufficient ground, even if you are arguing bail pending trial, to deny bail. But on this lower threshold of a balance of probability, where we are asking you to let us complete investigations, the likelihood to interfere with investigations, as my brother will tell you, where there has been uncontroverted evidence of interference with CCTV, that likelihood is very high. And because of the blue code, please hold the respondent for at least 21 days. I submit and I humbly pray. Thank you very much.
Occupied the gate of Arambe house and we are not going.
Wasimame wapi? Hapa the second ama the third? Hapa. Hapa ndipo hapo. Hapa hii hapa ile hapa. Mam jo. Hapo. Mam na wife hapo.
Kunywa yogurt yako. Iko
ama nikubebe.
Wakili, wacha
management address. The lawyer, IPOA, to come here with the family so that their statements may be recorded. And I wish to confirm that we have been here since 11:30 a.m. and we have seen the commissioners of IPOA. We have also seen the investigators, and I wish to confirm also that the statements of the immediate family members, the father, the mother, the wife of the deceased, and an uncle, have been taken. Right now, the said statements are being typed. We will be required to proofread them before they can sign. So that is what we have been doing since 11 up to now. We take note of the happenings of the last 24 hours. We are informed, or we have seen through the media, that some people have been arrested and were arraigned in court today. We, however, wish to say that like one of the people who was arrested yesterday, we are informed is a police constable from Central Police Station. We take note of that, but we wish to say that a police constable is the junior most officer in the hierarchy of the police and does not have control or does not run a police station. What that means, therefore, is that we expect much more from these investigations. We expect to see more senior people taking responsibility. We expect to see people who are the masterminds of this heinous act that took the life of our brother taking responsibility. So as of now, we do not wish to speak much because, as you all know, investigations are still ongoing. IPOA is still recording statements, is still summoning people. We do not know what they're going to do next. But up to this moment, all that we can say is that we expect all the investigative agencies of the state, especially IPOA, to take lead in this matter and may heads roll. We do not want to be hoodwinked by the arrest of a junior officer and then be told that investigations have been conducted and that is the gentleman that has been found culpable. The family believes that there are more people there. I would give a chance to my brother here, the deceased's uncle, to also speak on behalf of the family.
Okay.
Let's exchange.
Change places. Okay. Wakili, switch again.
Okay, good evening, everyone. We want to thank you. My name is Ken. Yeah, we want to thank everyone who is mourning with us, and a lot of people have come to us to mourn with us, and we want to put it to the public that we thank everyone. Now there are a few things we want to share with the public. I wish to tell everyone what the official pay bill is. We have 46 triple. We have 46 999 44. That is the official pay bill that the family is aware of. However, we also appreciate that everyone is in good faith trying to mourn with us. We are going to verify every information that is out, and every other channel of collection is going to be reconciled and merged with the official channel that is that I have said. The pay bill is 46 999 44. Account number is your name, and then we will receive and do reconciliation. However, if we will verify that any other that is in the public is okay, then we will give that information. Yes.
Okay, your full name and relationship.
My name is Kenneth Ouma. Yes, Kenneth Ouma, an uncle to the deceased. Yeah. Yeah. Well, with regards to burial, we are still planning, and as soon as the date is out for burial, we will release the date officially, and we'll know the burial date.
Yeah, just one question.
Yes.
If you may allow us.
Yes.
There are some people or relatives you were speaking with.
Yeah.
Who are the last conversation?
But it was on Saturday, at a time when they were having lunch. So he was arrested on Saturday lunchtime. They were just about to, without having specific of time. Saturday the 7th.
And maybe the conversation he had along the way, you told that he spoke with, you have the perhaps he spoke with some relatives.
Well, he may have spoken with some relatives, but what we know that all the way from the time he was he left home, Mawego police, he was in conversation, and at some point he talked to the wife, he talked to some of his friends and relatives. Yes, there was with everybody, but yes, he was communicating with mm-hmm. Well, that one we can confirm later, not now. Yes. Yes. Well, as I said, we are open to all mourners. We are not in a position to disclose everyone who has come to mourn with us. Just like thousands of people are calling. So everybody is calling. Yeah. And again, we are not blocking the door for anyone. We are not in politics. We do not belong to any side of the political divide. We are simply mourners. And in our tradition as a family and as our culture dictates, we do not send away any mourner and in any form of the way they want to mourn with us. Yeah.
So just to say something, a constable cannot order a fuel of 800 kilometers, because Homa Bay to here is 400 going, 400 coming back, so that's 800 kilometers. Normally, when you go to a police, when you are in trouble, you call the police station and tell them you are in trouble, wanakuambianga tuma mafuta. Sasa Ojwang ndiye alituma mafuta achukuliwe. So there must be a very senior person who gave those orders, who can even give order to a polling station in Mawego, because we know hierarchy of orders. Normally, a constable in Nairobi cannot order OCS in Mawego. It's impossible in hierarchy of orders. So the stories the policemen are telling all the security operators is so inconsistent, which is very clear it's a lie, because to tell a lie is the most difficult thing I've ever seen. But to say the truth, you just say it is, and it will coincide with everything else that we know. So we don't want distractions. The officers are giving too many information, which are too much contradicting for strategic reasons that they know, and we are aware of those things. So what I want to tell Kenyans is that we are mourning. Let the family mourn their way. Let them pick the phone calls from whom they want, and they should not reveal for you a private phone call, because I'm sure you don't tell us the same. And I want to urge also the public that most important thing, we pray. As our culture, we are on holiday, even with the politics. We are on holiday. When you mourn, even if you're a politician, you suspend. You don't go to Shamba, you just mourn, because this is the only time you have to mourn. Allow the family to mourn, support them the way they want, be consistent in the numbers given by Ken. If you have some information to ask, they are official person, you can ask the family lawyer. And at the same time, if you have any support, please channel them. Don't publicize this too much, because nobody wants to be seen as someone begging for help. Let's just be channeling. And I want to say that IPOA should do what they are doing. We are monitoring. We don't want to tell you where things are wrong, but we are monitoring everything. We also have our own evidence that we are collecting. IPOA is doing the evidence. IMLU is doing the evidence. LSK is doing the evidence. Other civil society doing the evidence. Family are doing their evidence. Even the samples taken in the mortuary, all family have their samples. IPOA have their samples. Other people have their samples. So we have to corroborate all those samples. And should we agree as 10 institutions, and IPOA has another story, you know very well that you cannot falsify 10 people's stories with one person's story. So the truth will come. We know very well, as our culture in Luo, the body speaks to us, and the body will tell us, and they have spoken, and the evidence is out there. All lies have been falsified. And I want to say, as a civil society leader, I am not taking the apology of the Inspector General, Kanja, by telling us that he is apologizing for giving a wrong statement. He has to tell the intention, the source of that false statement, and tell us what he was trying to achieve with it, because you can't just give a false statement that somebody's son has hit their head on the wall. We don't commit suicide. For us, we die when crime comes, and if not, then somebody takes their life. So we don't want to hear apologies which are distracting us. So we are not taking the apology, and I can say that even on behalf of the family. It is wrong to lie about somebody's life. Thank you.
Who are you introduction the next time?
Professor Fred Ogola.
So wakili wao waweze kuja kuandikisha statement na tunaweza kuconfirm kwamba statement ya